You work your whole life to pay off a California home, hoping to leave your kids a legacy. But instead of inheriting peace of mind, grieving families often inherit a grueling bureaucratic nightmare. It's called California Probate Court. It routinely locks up your property for 12 to 18 months and drains tens of thousands of dollars in mandated attorney fees before your family sees a dime. Most people are told the only way to avoid this is a living trust. A trust works beautifully, but it creates a high barrier to entry. You have to pay a lawyer thousands of dollars right now to set it up. There is a specialized alternative. The California Transfer on Death Deed is a low-cost probate killing document. It allows your property to bypass the court system entirely and transfer to your heirs the moment you pass away. This chart maps out the stark financial reality for a standard $500,000 home. Look at the paths. Probate will burn through at least $28,000. A living trust costs around $1,500 to create, but the transfer on death deed costs a few $100s for professional forms and $30 to record. By focusing on that final column, we see the massive return on investment. You keep over $27,000 in your family's pocket for the price of a dinner out. You want those savings. But you're likely terrified that if you handle legal documents yourself, a simple mistake will leave your children trapped in the exact disaster you tried to avoid. That fear is completely valid. This deed is an incredibly powerful tool, but it operates as a blunt instrument. It demands absolute zero-tolerance precision to execute correctly. Choosing this path requires a strict trade-off. You skip the high upfront cost of an attorney, but you accept a process that offers zero flexibility if you fill out the paperwork wrong. Before we get to the strict rules, let's look at why this deed is so strategic. First, you keep 100% control of your property while you are alive. Because the transfer only triggers at death, you can sell the house, pull cash out with a refinance, or tear up the deed entirely. You never have to ask your beneficiaries for permission. Compare that to a quitclaim deed or joint tenancy. If you add your son or daughter to your title right now, you instantly surrender sole ownership, and your house becomes vulnerable to their lawsuits, divorces, or creditors. This graph shows what happens if you gift your house to your kids before you die. They inherit your original low purchase price from 1985. When they sell, that massive gap between the old price and today's market value triggers a devastating capital gains tax. But with a transfer on death deed, the IRS resets the property's baseline to current market rates. That taxable gap is completely wiped out. This creates a dual advantage. The deed bypasses the probate courts and acts as a critical tax shield, saving your heirs hundreds of thousands of dollars when they sell the home. However, California real estate has a severe tax trap you have to navigate carefully, Proposition 19. To pass down property without tax reassessment, it must be your primary residence, and your child must make it their primary residence within 1 year. If so, taxes stay low. But for an investment or vacation home, there is no protection. The county will immediately reassess that property to full current market value. Your children will see their annual property tax bill jump by thousands of dollars, literally overnight. The deed itself doesn't cause this tax hike, but blindly applying a transfer on death deed to the wrong classification of real estate will walk your family straight into the reassessment trap. Using this document for anything other than a primary residence your kids plan to live in carries high financial risk. If you have rental properties, you need a tax professional, not a standard form. If your property does qualify, you still have to survive the execution rules. The state of California actively looks for reasons to invalidate these documents. The probate code provides zero margin for error. Your document must meet exact 1-inch margin requirements and include heavily mandated word-for-word statutory warnings. The property's legal description and the assessor's parcel number must match your original deed flawlessly. A single typo in a tract number breaks the chain of title. Even a perfectly typed, perfectly notarized deed is entirely useless if you leave it sitting in a desk drawer. By law, it must be officially filed with the county recorder before you pass away. And the requirement most people miss? Once recorded, you have exactly 60 days to formally notify your named beneficiaries using a specific legal process. Miss that notice, miss the filing deadline, or misspell a street name, and the deed is void. Your property goes straight into the expensive probate court you were trying to avoid. Responsible estate planning requires matching the right legal tool to your family's exact dynamics. Let's look at this decision tree. If you have minor children, own multiple properties, or need to navigate Medi-Cal long-term care planning, the deed fails. You are firmly in the red zone and require a living trust. Now track the right side. If you own a single primary residence, your kids are responsible adults, and your family gets along, you hit the green zone. You are the ideal candidate for a transfer on death deed. Pay special attention to the age of your heirs. Minors cannot legally hold title to real estate in California. Naming a 12-year-old on this deed forces the courts to step in and appoint a guardian, freezing the asset. Likewise, if you have a blended family, or you want to delay exactly when a beneficiary gets the house, you cannot use this form. You have to hire a lawyer to write custom rules into a trust. If your life maps perfectly to that green side, you are in a uniquely fortunate position. You can safely secure your legacy without paying attorney fees. When your family estate is simple and straightforward, this deed is the ultimate efficiency hack to strip away bureaucracy and protect your heirs' inheritance. Because California's property laws are so unforgiving, guessing your way through the probate code with a generic internet template is a massive gamble. The solution for ideal candidates is to utilize a professionally prepared, statutorily precise document package. The correct package must go beyond just providing the deed. It has to include the mandatory beneficiary notice templates and the required preliminary change of ownership report for the county assessor. Don't leave your family's inheritance to chance. Click the link in the description to download the complete, compliant California Transfer on Death Deed package and secure your legacy today.